participants, welcome to the 110th session of Legal Empowerment Through Interaction lecture series, the journey of discovery, empowerment and exposure to different thoughts, ideas and I would say like new ideas are being put across. We deliberate, we discuss, we at times dispute, but end of the day, we all go home enriched. So today, a very pertinent and very relevant topic, that is to dealing with government contracts, the discretion of the government, the law relating to government tenders, and all those things will be dealt with us, shared with us by a wonderful speaker, Justice Rajasekhar Mantha. He is a judge of the Calcutta High Court. We are especially thankful to Somayajulu sir for taking the initiative, and through Vijay also that we were able to get this wonderful speaker. We recognize the presence of Justice Ramkumar, Justice Ramushan sir, Justice Raman sir, and all of you, Somayajulu sir, and all of you wonderful participants. Dr. Vijay Kumar is also here. Welcome, sir. All of you to this 110th session of Legal Empowerment Through Interaction lecture series. This being a thoroughly informal session and platform, but only in-depth analysis happens here. So, without anything more, directly over to you, Justice Rajasekhar sir, for your presentation.
A very good afternoon to everybody. It's an honor, pleasure, and privilege to be speaking amongst legal luminaries, students, and people interested in the law in this area. We come straight to our topic, which is the law relating to government tenders and contracts. The government in a welfare state is the regulator and provides a large number of services and infrastructural facilities. It also engages in some businesses for greater good of citizens. For the said purpose, the state and its instrumentalities enter into contracts. Contracts, they issue licenses, then there are quotas and concessions issued. Such process generates employment, job opportunities, business opportunities, promotes trade and practice in the country. This results in the distribution of state largesse. Many enterprises have been set up primarily to do business with the government. The state thus, instead of procuring on its own, outsources these functions. The subject matter of the discussion is the law relating to government discretion to confer such benefits. The state and its instrumentalities are required to ensure that no injustice is done in distribution of state largesse. An equal opportunity regime must be the basis of such distribution, and this has to be balanced with the discretion and the right of the state to enter into a contract with a person of its choice. The balance is to be achieved is in the interest of the state on one hand, and the constitutional rights of citizens under Article 14 and 19(1)(g) of the Constitution of India. The constitutional provisions relating to government contracts and the power of the state and central government to enter into contracts in the first place is enshrined and located at Article 298 and 299(1) of the Constitution of India. I will not go deeper into those articles. Suffice it to say that any government contract is substantially similar to a contract entered into between private citizens and corporations in the country, except that there are three requirements. One, a government contract to be enforceable is required to be entered in the name of the governor or the president of India, governor of the state or the president of India. Secondly, it is different from this point of view that in respect of private contracts, that is non-governmental contracts, you can infer a contract which is oral, you can infer a contract based on correspondence, but insofar as government contracts are concerned, these two factors will not be considered for being enforcement of a valid contract against the central government or the state government for that matter. There's a decision on this of the Supreme Court in Chaturbhuj Vithaldas Jasani versus Moreshwar Parsharam is reported in AIR 1954 Supreme Court, page 236. The Supreme Court held that a contract that does not meet the criteria of Article 299 is not binding on the state. For example, an oral contract or a contract that is built up on the exchange of correspondence, as I was just telling you. Public procurement in this country is guided by the public procurement policy of India, which is pronounced and revised every year. You must have heard of this Make in India trend that is going on, which is part of the official policy of the government of India. This is an example of this public procurement policy. Until the Ramanna Shetty decision, the government awarded public contracts at its exclusive and own free will and discretion. It is only after the Ramanna decision that the public tender process of procurement came to be followed mandatorily. This is in respect of state largesse. The Public Procurement Bill of 2011, this is just an example I give. The Public Procurement Bill of 2011 was substantially based on the UNCITRAL model law of July 2011. The expression NIT, a lot of you are aware of this, but for those students who are not aware of it, I will just briefly indicate that NIT means Notice Inviting Tenders. Under the Contract Act, it is an invitation to submit offers, to submit bids. So a publication of a notice inviting tenders does not constitute an offer at all. It is only a notice to the public at large and to interested persons to submit bids, to submit offers. This is an expression that is recognized under the Contract Act. There has to be an offer. An unconditional acceptance of this offer will lead to a contract, but not against the government until a formal contract is executed in the name of the President of the Union or the Governor of the state. It is only the acceptance. There, in respect of tenders, public tenders, there are generally two parts to a tender, a public tender. In most common accepted, in at least 90% of the cases. First is a technical specification. The other part is the price or financial part, or the financial bid or the price bid. I will give you an example. Let us say in respect of construction of a bridge, the central government wishes to float tenders and appoint private contractors or contractors per se, including government, to construct the bridge. They would normally publish a notice inviting tenders to be submitted in two parts. The first part is the technical specification. That is, what will be the material built for used for the building of the bridge? What will be the length? What will be the design? What will be the longevity? What will be the inputs required? What will be best inputs required? In the process, the government knows exactly what it has in mind, number one. Number two, what it is like, what is receiving as offers, in which case there have been instances where the government has in fact gone and changed these specifications and has agreed to a bid submitted by one party. Consequently, after being satisfied and with the technical part of the bid, which is called the clearance of the technical bid, it is only then that the financial bids of the parties are opened. Mind you, we have come across these instances as rules in every state and as well as central government contracts, including international banks and international funding organizations who monitor these contracts. They say that as and when the technical bid is amended or changed at the instance of of one of the parties or the bidder on a clarification being sought by the employer. The employer is the government. an opportunity is always given to the concerned bidder to revise his financial bid and to resubmit it, because pursuant to the clarification sought by the employer and given by the bidder, there may be financial implications on the offerer. Let us straight away therefore come to, having got a brief overview of how these tenders function and what are the basic technicalities, very basic technicalities, we shall straight away delve into the law as to how the process, how the Supreme Court has in fact laid down in no uncertain terms over the years the norms which the central government is, or the state government or the procurer is required to follow, which have been codified by each of these organizations and the procurers, whether directly they are the state or the instrumentalities of the state, into their respective norms. In Ramanna Dayaram Shetty, that is the first major decision of the Supreme Court on the subject, versus International Airport Authority. This is reported in 1979, volume 3, Supreme Court cases, page 489. A notice inviting tenders for putting up and running a second-class restaurant and 2 snack bars at the International Airport at Mumbai was issued by the respondent number 1, which is a corporate body constituted under the International Airport Authority Act of 1971. The notice stated in clearest terms in paragraph 1 that sealed tenders in prescribed form are hereby invited for registered second-class hoteliers having at least 5 years experience for putting up and running a second-class restaurant and 2 snack bars at this airport for a period of 3 years. The successful tenderer did not possess the qualification as a hotelier, but was successfully running many canteens in various corporate houses. He also quoted the highest amount of license fees that he was willing to pay to the International Airport Authority. The appellant, that is Ramanna Dayaram Shetty, appellant did not actually participate in the tender process, challenged the award of tender inter alia on the ground that the state was bound by the tender conditions and could not have awarded the contract to the person concerned who was the successful bidder. The appeal was allowed on questions of law, but the actual decision of the airport authority was not interfered with by the Supreme Court. The observations of the Supreme Court in the said decision have been followed right from 1979 all the way down to 2020. And this is, in fact, one of the finest hours of the Supreme Court, where the law in this regard was laid down by judicial dicta, a very, very English practice, because there was no uniform law that could be found in the country, and even today is not found, because each government department has its own set of rules and norms. Today we have an attempt over the years for streamlining of all these norms into what could be defined as the law with regard to government contract and tenders. The Supreme Court observed government owns and controls hundreds of acres of public land valuable for mining and other purposes. These resources are available for utilization by private corporations and individuals by way of lease or license. All these mean growth in government largesse and the increasing magnitude and range of governmental functions as we move closer to a welfare state. More and more of our wealth consists of these new forms. Some of these forms of wealth may be in the nature of legal rights, but the large majority of them are in the nature of privileges. But on that account, can it be said that they do not enjoy a legal protection? Can they be regarded as gratuity furnished by the state so that the state may withhold or grant or revoke at its own pleasure? Is the position of the government in respect of the same as that of a private giver? We do not think so. The law has not been slow to recognize the importance of this new kind of wealth, and we need to protect individual interest in it. And with that end in view, it has developed new forms of protection. Some interest in government largesse commonly regarded as privileges have been recognized as rights, while others have been given legal protection not only by forging procedural safeguards, but also by confining structuring and checking government discretion in the matter of grant of such largesse. The discretion of the government has been held not to be unlimited, in that the government cannot give or withhold largesse in its arbitrary discretion or at its sweet will. The government cannot be permitted to say that it will give jobs or enter into contracts or issue quotas or licenses only in favor of those having grey hair or belonging to a particular political party or professing a particular religious faith. The government is still government when it acts in the matter of granting largesse, and it cannot act arbitrarily. It does not stand in the same position as a private giver, as a private individual. This is the basic essence of the thought process that began insofar as government tendering is concerned and distribution of state largesse. The Supreme Court in the Ramanna case followed the judgment of E.P. Royappa versus State of Tamil Nadu, as also the Maneka Gandhi, with some say Menaka Gandhi versus Union of India, that Article 14 strikes arbitrariness in state action and ensures fairness and equality of treatment. The court observed further at paragraph 21 that it must therefore follow as a necessary corollary from the principle of equality enshrined in Article 14 that though the state is entitled to refuse to enter into relationship with anyone, yet if it does, it cannot arbitrarily choose any person it likes for entering into such relationship and discriminate between persons similarly circumstanced, but it must act in conformity with some standard of principle which meets the test of reasonableness and non-discrimination, and any departure from such standard or principle would be invalid unless it can be supported or justified with some rationale or non-discriminatory ground. While aggrieving the Supreme Court in the Shetty decision, Ramanna Shetty decision, while agreeing with the observations made in V. Purna Thomas versus State of Kerala, reported in AIR 1969 Kerala, page 81, the Supreme Court stated the government is not and should not be as free as an individual in selecting recipients of its largesse. On the binding nature of tender conditions, that is the NIT conditions, the Supreme Court in the Ramanna decision held, it is well settled rule of administrative law that an executive authority must be rigorously held to the standards by which it professes its action to be judged, and it must scrupulously observe these standards on pain of invalidation or violation of them. The rule thus enunciated by the US Supreme Court in Vittervali versus Satan, this is 359 US page 535, in the following words, that is the US Supreme Court has said, an executive agency must be rigorously held to the standards by which it professes its action to be judged. The judicially evolved rule of administrative law is now firmly established. He that takes procedural sword shall perish with that sword. The Supreme Court had already accepted this rule as valid and had added and applicable in the decision of A.S. Ahmedwalia versus Punjab, reported in 1975, Volume 3, Supreme Court Cases 503, and in Sukhdev versus Bhagatram, reported in 1975, SCC page 421, and subsequently in the B.S. Minhas versus ISI decision. This could be stated, according to me, this could be stated as the beginning of the accountability and scrutiny regime on the state. Since the government no longer enjoys the absolute discretion to enter into a contract with anyone, the government must choose the party in a non-discriminatory manner. The state must act fairly and make a choice in the selection of a contracting party by affording equal opportunity to all contenders after examining their claims fairly. Government discretion is not unlimited, that it can give or withhold largesse arbitrarily, but its action must be informed with and conform to reason. The Ramanna doctrine was subsequently affirmed in Kasturi Lal versus Jammu and Kashmir. I'm just giving you a few examples where the Ramanna doctrine was adopted. There have been hundreds of other decisions. I'm just giving you a few ones. The Ramanna doctrine was subsequently affirmed in Kasturi Lal versus Jammu and Kashmir, reported in 1980, Volume 4, Supreme Court Cases, page 1, where it is unambiguously observed that the decision-making process of the government or its instrumentality should exclude remote possibility of discrimination, arbitrariness, and favoritism. It should be transparent, bona fide, and in public interest. The Supreme Court in Meerut Development Authority versus Association of Management Studies, this is reported in 2009, Volume 6, Supreme Court Cases, page 171, further examined the award of contract in the light of Article 14 and held that the action taken by the authorities in awarding a contract can be judged and tested in the light of Article 14 also. In Harmandar Singh Arora, so we have equality as enshrined in Article 14. We have absence of arbitrariness. We have non-discrimination. These are words used. Non-discrimination may find its place in Article 14 itself, but in the context of government contracts, the expression discrimination may assume a slightly different perspective, and hence this decision would be of relevance. The next decision that I found interesting was Harmandar Singh Arora versus Union of India. This is reported in 1986, Volume 3, Supreme Court Cases, at page 247. The court dealt with a case in which tenders were invited for supply of milk. The contract was awarded to a state undertaking by rejecting the offer of an admittedly more suitable but a private party. The Supreme Court cancelled the grant of tender by holding that the instrumentalities of state cannot act arbitrarily. If it chooses to invite tenders, it must abide by the conditions specified in the tender of notice. If a party, even if it's an instrumentality of the state, fails to fulfill the conditions of the tender notice, cannot to be accepted. So you find that here a private individual is given preference over the state, and admittedly the state authority did not fulfill all the requirements of the NIT. In further course of our discussion, we will find how this has changed slightly. Has it changed? Is a question that I'll be posing to myself, and maybe some of the participants would want to contribute here also. However, in respect of the conditions of eligibility, strict compliance is required. In other words, the state and its instrumentalities are required to abide by published norms. Such norms and standards and procedures cannot be departed from arbitrarily. However, the Supreme Court classified the terms of NIT. This is interesting. The Supreme Court clarified the terms of the NIT into two categories. Those which lay down the essential conditions of eligibility, and others which are merely ancillary or subsidiary to the main object to be achieved by this condition. If there are essential tender conditions, the same must be adhered to, and in other cases it must be open to the state or its instrumentality to deviate from and not to insist upon strict compliance. This is, I believe, in my limited understanding, the beginning of the discretion on the part of the state being also given appropriate primacy, as we shall see in the main decision that came later, which is the Tata Cellular decision, which I shall presently come to. In the next decision is Poddar Steel Corporation versus Ganesh Engineering Works, which is reported in 1991, Volume 3, Supreme Court Cases, page 273. The question arose concerning conditions of a tender as the successful bidder made payment of the earnest money by sending a check drawn on Union Bank of India, which is a nationalized bank at that point of time, still is a nationalized bank today, but not the State Bank of India, which is part of the tender condition. The Supreme Court, however, held, as a matter of general proposition, it cannot be held that an authority inviting tenders is bound to give effect to every term mentioned in the notice in meticulous detail, and is not entitled to waive even technical irregularity of little or no significance. Please mind you, here the Supreme Court is upholding this fact that the issuance of the check in the name of a nationalized bank is not a serious deviation, because although the tender stipulation was, please send a demand draft of the check issued by State Bank of India. Union Bank DD was given. The Supreme Court very rightly and appropriately said, this cannot be such a major violation or infraction of the terms of the NIT, and hence rejected the contention of the state. Now coming to the major decision which summarized the law with regard to tenders, discretion of the state on one hand, and the rights of private individuals and the private corporations in the country on the other. In Tata Cellular versus Union of India, reported in 1994, volume 6, Supreme Court cases, page 651, the Department of Telecommunications, Government of India, published notice inviting tenders from Indian companies with a view to license the operation of cellular mobile telephone service in 4 metropolitan cities in India, that is Delhi, Bombay, Calcutta and Madras. After the tenders were received, the Technical Evaluation Committee, which is generally called the TEC, changed the criteria and the selection process and held that tenders would be awarded to one bidder to each of the metros, that is one bidder per metro per metro city. Some tenders were rejected on various grounds, including eligibility. In the writ petition filed in the Delhi High Court, the tender process was challenged on the following grounds. The entire goalpost was changed according to the tenderers. But the change effected by the state, by the Department of Telecom, was upheld by the Supreme Court. The grounds on which the tenderers went to the Delhi High Court were these. First was bias. Second was invoking hidden criteria, irrelevant consideration, bypassing the selection committee, selecting otherwise unqualified parties, and marketing system which was evaluated by the Technical Evaluation Committee for for grading of bidders was challenged. The Supreme Court for the first time coined what I would call as the fair play in the joints theory. And this is watershed according to me. At page 687 of the decision, the Supreme Court summarized the law with regard to judicial review of tender processes as follows. The modern trend points towards judicial restraint in administrative action. The court does not sit in appeal, but merely reviews the manner in which the decision is made. That is, not the decision itself, but the decision-making process. The court does not have the expertise to correct the administrative decision. If a review of administrative decision is permitted, it will be substituting its own decision without necessary expertise, which itself may be fallible. Our courts are not experts. It is the administrative authority or the concerned authority or the employer or the owner that is the person who will actually take the decision. The courts only test the decision-making process. This principle has been applied why only in tenders, in administrative law and constitutional law across the board in this country. The terms of invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in the realm of contract. The government must have the freedom of contract. In other words, a fair play in the joints is a necessary concomitant for administrative body to functioning in an administrative or quasi-administrative sphere. However, the decision can be tested by application of the Wednesbury principle of reasonableness. The decision should be free from arbitrariness, not affected by bias or actuated by malefides. This Wednesbury test I'll just briefly deviate here. Most of you must have gone through this judgment. It is a 2.5-page decision of the Court of Appeals. In those 2.5 pages, a small paragraph was addressed against testing a decision of the Wednesbury Corporation, which is a borough in London. And a cinema house was challenging an action of the concerned borough of the corporation. This 1.5 to 2.5 pages decision has been discussed and delved in and expanded so widely by our Supreme Court that today India in the common law world is one of the leading countries, leading judiciaries insofar as administrative law is concerned. And I say this with a lot of pride, and I'm sure all of you have the same pride in this regard. Quashing decisions may impose administrative burden on the administration and lead to increased added unbudgeted expenditure. So you find that a harmonious balance was sought to be achieved by the Supreme Court in this watershed Tata Cellular decision. The play in the joints, that is greater discretion, was allowed to a state authority, not just for the purpose of the actual selection, but also in the decision-making process. Minor deviations not hurting anybody else can definitely be permitted. Secondly, if a person who has quoted a much higher price is also given the tender, those must be left to the essential discretion of the state, because a court of law is not an expert either in bridge building or road construction or supply of canteens and food to hospitals. These are areas in which tenders are generally invited. The next major decision which reiterated the Tata Cellular decision, and there have been many more, but I found Raunak International Limited versus IVR Construction Limited, reported in 1999, Volume 1, Supreme Court Cases, page 492, to be extremely relevant. The Supreme Court held that the administrative authority has a discretion and must be allowed play in the joints in the process of tendering. Authority, the MSCB, that is a Maharashtra State Electricity Board, had invited tenders in the year 1997 for commissioning steel pipes and tanks at one of their power plants at Khaparkheda. 11 bids were received, for which 4, including that of IVR, the respondent, were found to be technically valid. As for the appellant, it was stated that the technical evaluator, that though they did not meet the technical criteria, they had experience in similar works. The contract was awarded to the appellant and the respondent, IVR, challenged the same. Just 1 minute, please. Right. The fair play in the joints theory in the Tata Cellular case was reiterated, and it was held in paragraph 9 that the award of contract, whether it is by a private party or by a public body or the state, is essentially a commercial transaction. In arriving at a commercial decision, considerations which are of paramount importance are commercial considerations. These would be, according to the Supreme Court, the price at which the other side is willing to do the work, 1. 2, whether the goods or services offered are of requisite specifications. 3, whether the person tendering has the ability to deliver goods or services as per specifications. When large works contracts involving engagement of substantial manpower or requiring specific skills are to be offered, the financial ability of the tenderer to fulfill the requirements of the job is also important. The ability of the tenderer to deliver goods or services to do the work of requisite standard and quality has to be considered. The past experience of the tenderer, whether he has successfully completed similar work earlier, the time which will be taken to deliver the goods or services, and often the ability of the tenderer to take follow-up action, rectify defects, or post-contract events. Even when the state or public body enters into a commercial transactions, considerations which would prevail in its decision to award the contract to a given party would be the same. However, because the state or the public body or an agency of the state enters into such contract, there could be in a given case an element of public law or in public interest involved, even in such commercial transactions. At paragraph 16, the highest bidder right, or the right of the person who bid the highest price, his right was that right was rejected and was explained as thus. At paragraph 16, it is also necessary to remember that price may not always be the sole criteria for awarding a contract. Often when an evaluation committee of experts is appointed to evaluate offers, the expert committee's special knowledge plays a decisive role in deciding which is the best offer. Price offered is only one criteria. The past record of the tenderers, the quality of goods or services which are offered, assessing such quality on the basis of past performance of the tenderer, its market reputation, and so on, all play an important role in deciding to whom the contract would be awarded. At times, a higher price for a much better quality of work can legitimately be paid in order to secure proper performance of contract and good quality work, which is as much in public interest. Kindly mark this. There is a lower person who is quoted lower, but there is another person who is quoted much higher. It will cost the government more, but the government accepts that higher bid. Why? In the interest of quality, in the interest of the public at large, since public interest in public infrastructure is involved there. The court should not substitute, again, please, it's a reiteration. The court should not substitute its own decision for the decision of an expert evaluation committee. In this regard, for my colleague judges and for my own self, I would want to refer to one paragraph in which, although I will not place that paragraph, I will just refer to it, where the court said, Supreme Court said, passing of interim orders in tender-related matters, especially public tenders, would cause serious prejudice to the public works and public infrastructure. And the court was not happy with the High Court, which had passed an interim stay on the entire tender process. Do bear in mind that unless the tender process is shockingly mala fide, shockingly discriminatory, unexplained, even applying the basic Wednesbury principle, I'll just briefly tell you, all of you are aware, but for those of the students who are new to this area of law, I will just briefly indicate the Wednesbury test. They said, any man traveling on that Clapham omnibus, Clapham is a place in London, let us say, for Madras, any person traveling from Adayar to Paris on that particular bus, common man, will it shock his conscience? Will a common man come to this conclusion that the administrative authority has come with reasonable intelligence? This is the Wednesbury test, nothing more than that. The next decision, which would be relevant both in facts and law, it has reiterated Tata Cellular as also Raunak International in one form, but the facts are rather interesting. The decision is Michigan Rubber India Limited versus State of Karnataka, reported in 2012, volume 8, Supreme Court cases, page 216. The Honorable Supreme Court was considering a challenge to tender conditions issued and altered by the KSRTC, which is the Karnataka State Road Transport Corporation, for purchase of tires for its buses. By reason of changed criteria, the appellant, that is Michigan Rubber, who was an existing supplier, he was an existing supplier for 5 years continuously. He came to be excluded from the requirements for basic requirements for eligibility criteria. I mean, he was no longer eligible after the tender conditions were changed. Mind you, the tender conditions were changed during the pendency of the matter of one writ petition before the High Court. That writ petition possibly was abandoned and a fresh writ petition was filed thereafter after the change of the tender conditions. The Supreme Court held from the above decisions, that is Raunak, Tata Cellular, Ramana Dayaram, all the decisions were analyzed again. The basic requirement of Article 14 is fairness in action by the state and non-arbitrariness in essence, and the substance is the heartbeat of fair play. These actions are amenable to judicial review only to the extent that the state must act validly for a discernible reason and not whimsically for any ulterior purpose. If the state acts within the bounds of reasonableness, it would be legitimate to take into consideration national priorities. Fixation of the value of the tender is entirely within the purview of the executive, and the courts hardly have any role to play in this process except for striking down such action of the executive as is proved to be arbitrary or unreasonable. If the government acts in conformity with certain healthy standards and norms, such as awarding contracts by inviting tenders, in those circumstances, interference by the courts would be very, very limited. In the manner of formulating conditions of a tender document and awarding a contract, greater latitude is required to be conceded to the state authorities unless the action of the tendering authority is found to be malicious and a misuse of statutory powers. Interference by courts is not warranted. Certain preconditions or qualifications for tenders have to be laid down to ensure that the contractor has the capacity and the resources to successfully execute the work, and if the state or the instrumentalities act fairly and reasonably in public interest in awarding the contract, here again interference by the court is restrictive. Whether a process adopted or decision made by the authority is mala fide or intended to favor someone, or whether the process adopted or decision made is so arbitrary and irrational that the court can say this: the decision is such that no responsible authority acting reasonably and in accordance with the relevant law could have reached. Whether the public interest is affected, if the answers to the above questions are in the negative, there should be no interference under Article 226. The above decisions were referred to with approval by the Supreme Court, most recently in Ma Binda Express Carrier versus Northeastern Frontier Railway, reported in 2014, Volume 3, Supreme Court Cases, page 760. Most recently, that is on 18th March 2020, the Supreme Court, in the case of Bharat Coking Coal Limited versus AMR Devaprabha, approved the dicta of Michigan Rubber. And in paragraph 22, it has said this: this decision is not yet reported. It is available in the Supreme Court website. In cases where a constitutional right is infringed, writs would ordinarily be appropriate remedy. In tender matters, such can be either when a party seeks to hold the state to its duty of treating all persons equally or prohibit it from acting arbitrarily, or when the executive actions or legislative instruments are challenged for being in contravention to freedom of carrying trade or commerce, as available in Article 19(1)(g). However, writs are impermissible when the allegation is solely with regard to violation of contractual right or duty. Now, this sentence may be considered in a different context also. A lot of you may be aware of the decision of the Supreme Court in the case of AB International versus Export Credit Guarantee Corporation, ECGC, where the rejection of a claim by AB International by ECGC was stated to be illegal, and although arising out purely of a contract of insurance, and the ECGC was asked to pay up the money. This is the first major deviation from the general principle that writ courts don't interfere in areas of contract, and this AB International decision was approved by the Supreme Court again in the case of Joshi Technologies. The law students and advocates can just briefly look at the search for Joshi Technologies in Google or the relevant websites. It follows from the above that the policy decisions of public authorities are generally not interfered with under Article 226 of the Constitution of India. Interference is called for only when any vested right and benefits are sought to be deprived by such policy or change thereof. In BSN Joshi and Sony Limited versus Nair Coal Services, reported in 2006, volume 11 Supreme Court cases, page 548, the Honorable Supreme Court, after reviewing the judgment on the subject, laid down various legal principles with regard to government contract and tenders. To me, it is a reiteration in a different form of the principles laid down in Tata Cellular and Raunak International, both of which were reiterating again the Ramanna Dayaram Shetty doctrine. They just moved from laying down the basic principles which the state must follow, which was misunderstood by the high courts as to being interfere anywhere and everywhere, when Tata Cellular and Raunak International decided that interference will be an exception and not the rule. Further, the Supreme Court in Jagadish Mandal versus State of Orissa, this is reported in 2007, volume 14, Supreme Court cases 5 and 7, has held that if the decision relating to award of the contract is bona fide and is in the public interest, courts will not interfere in exercise of power of judicial review, even if a procedural aberration or error in assessment or prejudice to a tender is made out. See, as is now well settled in administrative law, not every procedural violation of any procedure is justiciable. Most of you are aware of the decision of the Supreme Court in the case of the State Bank of Patiala was S.K. Sharma, where the prejudice doctrine was laid down, where the Supreme Court said there may be a violation of some procedure in the decision-making process itself also. Some procedure or some method that is stipulated in the NIT is violated. One must be able to demonstrate before the courts as to how this has prejudiced the person who has come complaining of the violation or the infraction by the state authority. The shift in the scope of judicial interference is therefore clear and evident. There is greater emphasis on the discretion of the government, hence lesser interference by the courts, which is the order of the day. Interference by courts is, however, warranted in exceptional cases as discussed above. In the last 10 years, due to increased high-value tenders and contracts of the government work, the number of cases challenging the process followed in such granting of tenders is also increasing. On one side, the government is opposing this trend on the ground that it is an administrative function of the state, and that too with regard to commercial contracts, and hence courts should not intervene. But on the other hand, the other side, affected parties claim that there is gross misuse of statutory powers by the government authorities while exercising their administrative discretion in such matters. Very clearly, the coal allocation case and the spectrum allocation cases are examples in this regard, where auction has been held as mandatory. There has been some criticism in some quarters that following the auction method, maybe the government in fact did not benefit the amount to the extent that it ought to have, or the courts thought it to have. But the fact, however, remains that a appropriate and fair and transparent procedure must be evolved. Even giving all the discretion to the government, I would still say that give the discretion, but ensure that the best price is received, number one, and the best service or goods are received. After that process, I don't think the courts would interfere to that extent. One example, one decision that I will give in this regard is the case of Ravi Development versus Sri Krishna Pratishthan, reported in 2009, volume 7, Supreme Court cases 462. This I have put under the heading of pilot attempts and policy decisions. That is, if a new attempt is being made by the government to explore a new possibility, a person can't complain of violation of Article 14 or 19(1)(g). In this case, the subject matter was a Swiss challenge method, whereby the Maharashtra Housing Development Authority published a notice inviting tenders for development of some survey lands in the Thane district. The said method, that is the Swiss challenge method, involved was that the initiator of the proposal would be awarded the tender if he is able to match the highest bid received pursuant to the notice inviting tenders. The entire tender process, that is the Swiss challenge method, was explained in detail to all bidders. It was mentioned in the notice inviting tenders. The bidders, each of them acknowledged in writing before submitting their bids. The entire they acknowledged in writing that even if one of them is the highest bidder, Ravi Development, who was the initiator of the concept, would be awarded the tender if Ravi Development is able to match the highest bidder. This was challenged before the High Court. The High Court struck down the award of tender to Ravi. The Supreme Court upheld the same and reversed the judgment of the High Court. It was held that the terms of the NIT and the mode of selection was in the exclusive domain of the state and was a policy decision which is not interfered with by the courts. It was found that the state was trying out a new method of tendering, the Swiss challenge method and the West Bengal joint venture method. These two methods of tendering were placed before the concerned ministry and the Chief Minister. The Chief Minister, after discussing with all his colleagues and the bureaucrats, decided, let us explore the Swiss challenge method. Such a decision, was found by the Supreme Court to be very transparent, within the domain of the state, and that they could adopt it, and the High Court's decision interfering with the tender award was set aside. While reiterating all the principles in Ramanna, Tata Cellular, the Supreme Court upheld the tender process. This is more or less an exception, a further exception drawn out from the basic doctrine laid down in the Ramanna case and the Tata Cellular case, which is a deviation. The shift is therefore from scrutiny of the state action to scrutiny only of the decision-making process. And the third stage is that even if a decision-making process, one particular norm or one particular procedure laid down was not followed, one must see what is the prejudice caused to the individual. And fourthly, the Ravi doctrine, which said that if the state was going to try out a new method of procurement, please don't interfere there. This is a transparent method. The state had advertised, state had informed everybody. It appeared at first glance to be favoring Ravi, but the court said no, Supreme Court. It's a pilot method. Everybody was informed that the person who initiated the process would be given an opportunity to meet the highest bid and the tender would be awarded to it. Having discussed this gamut, this is the basic trend and law relating to government tenders and contracts. We shall now enter into some of the allied aspects that I was talking of, which is part of the topic. Some allied aspects which I have encountered in course of my career as a lawyer and thereafter in course of the cases that came to me as a judge. The lesser known now, but widely prevalent at one point of time until recently, was carteling and predatory pricing. In the past, there have been cases where courts have been approached and or have found that some parties have engaged in formation of cartels to corner state largesse with ulterior motive and compel award of tenders to a designated bidder. In Union of India versus Hindustan Development Corporation, reported in 1993, Volume 3, Supreme Court Cases, page 499, at paragraph 14, cartels and predatory pricing was explained by the Supreme Court. First, we shall consider the submissions regarding formation of cartel by these three big manufacturers. Huge corporates in this country were party in those proceedings. The word cartel has a particular meaning with reference to monopolistic control of markets. In American Jurisprudence, second, volume 54, page 677, it is mentioned as thus: a cartel is an association by agreement of companies or section of companies having common interests, designed to prevent extreme or unfair competition and to allocate markets, and perhaps also exchange scientific and technical knowledge or patent rights, and to standardize products with competition regulated but not eliminated by substituting competition in quality, efficiency, service for price cutting. An international cartel agreement providing for worldwide division of market has been held per se violation of 15 U.S.C. Section 1. American corporation violates the Sherman Act by entering into agreements with the English and French companies to 1. Allocate world trade territories amongst themselves, fix prices on products of one sold in territories of others, cooperate to protect each other's markets and eliminate outside competition, and 4. Participate in cartels to restrict imports and exports from the United States. This is covered under the competition law in the US, the EU competition law, and various parts of the country, various parts of the world. It is also part of the competition law of this country. We know of no better statement of the rule than that of this court in the United States versus Society of IND Gasoline Marketers, reported in 624 F. 2nd, page 461 and 465, where it is stated that since in a price fixing conspiracy the conduct is illegal per se, further inquiry on issues of intent or anti-competitive effect is not required. The mere existence of price fixing agreement establishes the defendant's illegal purpose, since the aim and result of every price fixing agreement, if effective, is the elimination of one form of competition. It was also observed that the critical analysis in determining whether a particular activity constitutes per se violation is whether the activity on its face seems to be as such. It would always or almost always restrict competition. In Matsushita Electric Industrial Company Limited versus Zenith Radio Corporation, reported in 9 LED 2nd 538. This is a case where American manufacturers of consumer electronic products brought a suit against a group of their Japanese competitors in the United States District Court, alleging that the competitors had violated Section 1 and 2 of the Sherman Act and other federal statutes. It was alleged that the Japanese companies had conspired since 1950 to drive domestic firms from the American market by maintaining artificially high prices for their products while selling them at a loss in the United States. The district court, after excluding the bulk of evidence, came to this: a predatory pricing conspiracy is by nature speculative. Any agreement to price below a competitive level requires the conspirators to forego profits, and that free competition would offer them. The foregone profits may be considered an investment for the future. For the investment to be rational, the conspirator must have a reasonable expectation of recovering in the form of later monopoly profits more than losses. The Apex Court discovered carteling and predatory actions by bidders in government tenders at paragraph 17 said, therefore, whether in a given case there was formation of a cartel by some of the manufacturers which amounts to an unfair trade practice depends on the available evidence and surrounding circumstances. So in essence, without going much deeper into this issue or the dicta laid down by the Supreme Court, suffice it to say that carteling and predatory pricing has been an issue that has been come to the notice of the Supreme Court. It is prevalent even to some degree in this country even today. It was widely prevalent at one given point of time. So one must be very cautious of this. I came across one decision before me, which I had rendered in the case of West Bengal Dairy and Poultry Development Corporation Limited versus Jayanti Bose. This is reported in 2018, SCC Online, page 1357. The above principle was applied by division bench of the Calcutta High Court following the dicta of the Supreme Court. At paragraph 33, it was stated that applying the aforesaid principle in the instant case, the reasons for cancellation of the first three tenders, three successive tenders floated by the West Bengal Dairy Development Corporation were cancelled by the authority. Why? The reason that we found was there was predatory pricing, there was carteling. 3 or 4 persons only quoted at all stages. One person was always the lowest bidder. And when it came to challenging the rejection of this bidder, none of the other 3 persons who were bidding higher than him either participated in the court or ever said that they were entitled to the contract. We found this. Applying the aforesaid principles in the instant case, the reason for cancellation of the first 3 tenders here and above are most definitely something more than a mere suspicion on the part of the appellant, that is the employer. The only 3 bidders in the first 3 tendering processes were all identical. In each of the 3 tendering processes, the writ petitioner respondents emerged marginally lower than the others. The writ petitioner was already enjoying the contract for 2 successive years prior to the 3 tendering processes. Equally strange is the fact that the 2 other tenderers who purportedly competed 3 consecutive times with the respondent writ petitioner chose to remain silent and were not aggrieved by the decision of the appellant to issue the tender for the 4th time. The aforesaid facts speak for themselves, and a reasonable man can definitely come to the conclusion that the respondent writ petitioner may be involved in some predatory measures for wresting the contract in her favor. For the reasons above, the floating of the 4th tender by the appellant in the facts of the case cannot be faulted and should not have been interfered by the single bench. Now we come to another aspect of tendering. Excuse me. This has intrigued me personally substantially. This is what I call the 2 contract issue. Let us see. We will straight away come to a decision of the Supreme Court in this regard. The 2 contract issue in summary is this. The notice inviting tender is published. The tender conditions are there. If there is violation of one tender condition and there is an arbitration clause in the tender conditions, would the aggrieved party be forced to go into arbitration instead of challenging that before the High Court or a civil court? Would the public nature of the issue be extinguished and go into the realm of arbitration? This is the 2 contract theory that is propounded by the Supreme Court. They said the notice inviting tenders portion is slightly different. It is a collateral contract. The main contract being the contract which is entered into by the state with the successful bidder, which is treated as a main contract as opposed to the collateral contract, which is the supplemental contract, which is between all the tenderers and the terms and the employer and the state, and under the notice inviting tenders. Two separate contracts were conceived of. The decision of the Supreme Court is National Highway Authority of India versus Ganga Enterprises. This is reported in 2003, volume 7, Supreme Court cases, page 410. The issue that came for consideration was whether a tenderer who withdrew his bid submitted a defective bid could prevent the forfeiture of his earnest money. At paragraph 9 of the decision, it was held as follows. The Indian Contract Act merely provides that a person can withdraw his offer before its acceptance. But withdrawal of an offer before it is accepted is a completely different aspect from forfeiture of earnest security money which has been given for a particular purpose. A person may have a right to withdraw his offer, but if he has made his offer on a condition that some earnest money will be forfeited for not entering into the contract, or if some act is not performed, then even though he may have a right to withdraw his offer, he has no right to claim the earnest money security to be returned to him. It would be an anomalous situation that a person who by his own conduct precludes the coming into existence of the contract is then given the advantage or benefit of his own wrong by not allowing forfeiture. The whole purpose of such a clause is to see that only genuine bids are received. The whole purpose of the contracting would be frustrated if forfeiture is not permitted. The question that arises is whether the terms and conditions of the tender and the rules therefore are a separate collateral contract for the purpose of the main contract to be entered with the successful bidder. The terms of the NIT are a separate contract, and the Supreme Court has held that all parties are bound by the terms of its tender. Is the process of tendering therefore in the domain of a contractual right? Or that since there is a public law element involved under Article 14 and 19(1)(g), as based on the principles of the Ramanna case, would the matter come within the domain of public law? Then a more liberal approach should have been adopted in the matter of refund of earnest money and not the strict contractual terms. This is a tight rope that all courts, high courts and Supreme Court, will be walking as to whether I will allow a refund of an earnest money. There is one matter that had come before me in the Calcutta High Court. The issue was with regard to allowing mining rights of coal floated by the DVC, the Damodar Valley Corporation. Each bidder was required to submit. The mining rights were to be given for a period of 15 years or much more than that. The earnest money amount was 19 crores that was to be given in the form of a bank guarantee. There was some issue with regard to the technical specifications of the bidder. The bid was rejected on the ground that there was one blacklisting clause and there was one blacklisting order passed by the Central Coalfields against this particular bidder. When I looked at the records, I found that the blacklisting order was stayed by the Bombay High Court. And subsequently, on the day when the bid was submitted, the blacklisting order was stayed. So technically speaking, there was no blacklisting order in the that was valid on the date of submission of the tender. The interim order was vacated by the Bombay High Court later. The blacklisting order had revived. So strictly speaking, on the date of evaluation, there was a blacklisting order, but on the date of submission of bid, there was no blacklisting order. Now, when matter came before us, it was heavily fought. some of the luminaries of the bar were all on the other side. They had 20 bags of books, each of them, and they were ready to go in hammer and tongs against each other for the next 15 days. I asked a simple question to the Damodar Valley Corporation, a very respectable council. I was appearing on their behalf. I asked him, Mr. So-and-so, 19 crores, easy money. Do you think you could have made this in your operational profits? He said, sir, we are entitled to, my lord, we are entitled to forfeit this earnest money. This is part of the terms of conditions of contract. I found that it is just and equitable to award 10 lakhs rupees, I think 5 or 6 lakhs rupees costs in favor of the DVC against the tenderer. And I told him, please take your earnest money and go away. So it is a tightrope that we will be walking in a given situation. The Canadian approach to this is rather interesting. I chose the Canadian, New Zealand, and the Australian and the English approach very briefly to highlight this point of the two contract principle. In Ontario versus Ron Engineering, reported in 1981, one SCR 111. This SCR is not our SCR. This is the Canadian SCR, that is the Supreme Court of Canada. The Supreme Court of Canada had said this: the tender submitted by Ron Engineering brought contract A, tendering contract, into life. This is sometimes described in law as a unilateral contract, or perhaps better termed a collateral contract. That is to say, a contract which results from an act made in response to an offer. As for example, in simplest terms, I will pay you $1 if you will cut my lawn. No obligation to cut the lawn exists in law, and the obligation to pay the dollar comes upon being performed of the invited act. Here, the call for tenders created no obligation in Ron Engineering or anyone else in or out of the construction world. When a member of the construction industry responds to a call for tenders as Ron Engineering has done here, that response takes the form of a submission of tender, or a bid as it is sometimes called. The significance of the bid is bid in law is that it at once becomes irrevocable if filed in conformity with the terms and conditions under which the call for tenders was made, and such terms so provide, which the tender was submitted by Ron Engineering, that it complied with the terms and conditions of call of tenders. Consequently, a contract A came into being. The principal term of contract A, in this case, is irrevocability of the bid, and the corollary term is the obligation in both parties to enter into a construction contract upon the acceptance of the tender. So they clearly follow the NIT being collateral contract and the main contract to be entered into being the principal contract. But the English courts in Blackpool and filed Aero Club versus Blackpool Borough Council, reported in 1990, Volume 3, All England Reports, page 25. The Court of Appeals said, was also of the view that tender conditions constituted a collateral contract. It was opined as follows by Bingham J. I will not go into much detail of this paragraph, except to say that the Australian approach, the Canadian approach, and the English approach are all the same. The Australian case is Hughes Aircraft Systems International versus Air Services Australia, reported in 1997, 146 ALR, page 1, in bracket FC Australia. The courts of New Zealand have also adopted the same doctrine, that is two contract theory. The New Zealand case is Pratt Contractors Limited versus Palmerston North City Council, reported in 1995, 1 New Zealand Law Reports 469. We now come to the next point, which may be the last point, is the arbitration clause. An issue did crop up before the Supreme Court as I was discussing earlier, slightly earlier, whether the infraction or an aggrieved tenderer, that is a person who lost the bid, whether he can be forced to go to arbitration and the 226 and the civil court remedy is shut out to him. Equally relevant in the context of the above issue is the arbitration clause in the NIT. An issue that came for consideration is as to whether the writ petition or the civil proceeding would be barred by reason of the arbitration clause in the NIT. In Zesser Rand SA versus Bindal Agrochem Limited, reported in 2006, Volume 1, Supreme Court Cases 751, at paragraph 27 and 32, the Supreme Court observed as follows: the tender document or invitation to bid of Bindal contain instructions to bidders and general conditions of purchase. By itself is neither an agreement nor a contract. This is a deviation from what the Commonwealth says. But is it too different? Because in the earlier case, the Supreme Court said EMD can be forfeited by a person who wants to unlawfully withdraw from the bid process after being awarded the tender. It's for us to judge. It is for my learned colleagues to assess and on their own. The instructions to bidders informed the intending bidders how the bid should be made and laid down the procedure for consideration and acceptance of the bid. The process of bidding or submission of tenders would result in a contract when a bid or offer is made by a prospective supplier and such a bid or offer is accepted by Bindal. The second part of the invitation to bid consists of general conditions of purchase, that is, the conditions subject to which the purchase order will be placed or offer will be accepted. The general conditions of purchase are made available as part of the invitation to bid so as to enable prospective suppliers to ascertain their obligations and formulate their offers suitably. Parties agreeing upon terms subject to which contract will be governed when made is not the same as entering into the contract itself. Similarly, agreeing upon the terms which will govern a purchase when a purchase order is placed is not the same as placing the purchase order. A prelude to the contract should not be confused with the contract itself. The purpose of revision 4 dated 10/6/91 was that if any purchase order was placed by Bindal, that would be governed by general conditions of purchase as modified. It was therefore held that the NIT conditions were just indicators and did not constitute a contract by reason of participation. This has to be reconciled with the earlier decision, which did not permit the earnest money to be given back to the bidder. The next and last case that I will be referring to is the decision of the Supreme Court in the case of BSNL versus Telephone Cables Limited, reported in 2010, Volume 5, Supreme Court Cases, page 213. At paragraph 18, the Supreme Court held the respondent contended that BSNL had entered into a contract with it in respect of a quantity, and as the dispute raised was whether the contract quantity should be more, the arbitration clause was in force and available. The Supreme Court said the contention has no merit. The arbitration agreement was available in regard to the contract for so and so. But in the absence of any purchase order in respect of 5.306 LCKM by the BSNL on the respondent cannot seek recourse to arbitration, as contained in clause 20 of section 3 of the bid document, in regard to a dispute relating to the quantity for which the order was not placed. It is sufficient to show that there was an arbitration agreement in regard to some contract between the parties. To constitute an arbitration agreement for the purposes of section 7 and 11 of the Act, two requirements should be satisfied. The first is that there should be an arbitration agreement between the parties to dispute. Second is that it should relate to or be applicable to dispute to which the appointment of arbitrator is sought. For the foregoing reasons, we hold that in the absence of an arbitration agreement, the application of Section 11 is not maintainable. So, these are some of my thoughts which I thought were relevant for the purpose of, one, understanding the discretion part given to the state for distribution of state largesse, and the rights of citizens and the rights of corporations, corporate bodies, corporate personalities against the state. The trend is definitely towards or against rather judicial interference. The trend is give as much leverage to the government as follows, but if it is shocking and bias, impropriety, unequal treatment is writ large, I'm sure the courts should not hesitate to interfere. These are my few thoughts. Thank you. Thank you so much for listening. Thank you so much.
Thank you very much, sir. It was an express presentation, I would say. Over to you, Ramkumar, sir, for your comments.
Before I make the comment, may I ask one doubt? No,
Yes, sir.
Sir, all these judicial review is only directed at the entry stage of contract. Am I right?
Absolutely. Before the contract.
Before the
Now,
contract.
this is the problem that I was trying to highlight. On one end, the Supreme Court says the NIT is not a contract, it is just an instruction to bidders. Whereas, in that case, the EMD for the purpose of the NIT should have been returned to the concerned person. In that case, the Supreme Court adopts the Commonwealth doctrine as in Australia, Canada, and New Zealand. They say that no, that's a collateral contract, and the main contract is the one that will be entered into. This is the difference, sir. This is a conflict that will be bothering all of us.
Exactly. Sir, excellent, lively and insightful articulation on the scope and amplitude of judicial review on the award of government contracts. Just as an ideal state is virtually unattainable, an error-free perfect contract is an impossibility as long as human agency is involved in the deliberations in the award of contract. It was an expert, it was a touch of class. Thank you, sir. Thank you very much for the insightful articulation. Thank you.
This is Ramkumar, sir. Maybe
sir, I have one question.
Ram, sir. Please, sir.
Whether is one aspect of the matter, probably I would have been a little more happy if you would have touched this.
Please.
The tailor-made contractual conditions or the tailor-made tender conditions, where if you look at today what is happening across the country.
In terrorism.
Yeah, no, in terrorism is the different aspect. The tailor-made conditions.
Okay.
Sir, take it or leave it. Contract of adhesion, no bargaining power.
No, prefixing of the tender conditions.
Correct.
To suit a particular
class of persons.
Particular class of persons, because the tender conditions are designed in such a way that in the end, except that 3 or 4 are already working in tandem, there may be, like, just give an example, there are 4, I don't want to take any corporate names, but there are mega engineering contracts where in the country there are only about 4 or 5 or 6 people who can do.
That is foreclosing the right of a new entrepreneur to come in.
Yes, the entry barrier is created. That's one aspect. The second aspect is
Justice Chaudhary, just Kodandaram, I mentioned the case of Michigan rubber. Now, if you see, I have deliberately avoided to mention the names of the 4 biggest players in the tire industry. I don't want to name them even now. Their names are available in the judgment. In the process of alteration of exactly what the point you have raised was there in Michigan rubber. A person who was supplying tires to the KSRTC for 5-6 years consecutively had a monopoly. The tender conditions were altered in such a way that he is excluded. And the major manufacturers of tires, we are all very common names. only those people qualified for bidding. This is a clear example of a tailor-made contract in the way you are saying, sir. But the Supreme Court did not interfere. The Supreme Court said, although the High Court interfered, the Supreme Court said no. They said that if the state wants a particular brand or category of financial status of a particular supplier, it is for them to decide. But as you have so very rightly pointed out, Mr. Justice Kodandaram, there may be many collateral interests behind tailor-making conditions of tender to, give benefit to a particular section.
Yes.
Sir, you and me at that end, we have our limitations as judges.
142.
Their power is different.
Yes.
Their power is different, sir.
Special category made for them only.
No, because the vacating stance which the Supreme Court, leaving the verbose and I generally keep saying that quote and conclude culture. And you borrow under nice expressions, and maybe down the south, some of us are not so good in English. In Andhra people, we are you are also Telugu man.
Accent.
Laced with Telugu, and Kerala it's laced with the Malayalam, and Tamilians they also laced with something else. But we are all very
Same in Bengal, sir. Same in Bengal. Same in everywhere. Orissa, everywhere, sir.
When it comes to analysis, it's the High Court judges who take more pain to get into the nitty-gritties and they examine each of the facts, and also they are aware of the ground realities.
Sir,
as you said, 142.
I just interrupt here. Everybody must have heard of Justice Ruma Pal of the Supreme Court,
Yes.
a former judge, a lady who we are very proud of for her erudition in law, and apart from the integrity, one of the highest levels, unmatchable, in fact, unimaginable for most of us. I was arguing a matter before her. This came in the context of the English language. She said, and very rightly so, we don't understand this language. We don't know how to speak it. We say something, we mean something else. Something else is understood. And the worst of all, the sixth thing is done. Why don't we get rid of this language once and for all? And we should really encourage our own mother tongues. We have 25 proud languages of this country, sir. I don't know why we don't talk. I mean, it's a shame that we can't still converse with each other in a language of our own country.
Exactly.
Oh, excellent presentation, brother. In fact, I had taken notes. I'll be happy if I can request Shyam to ensure that it is circulated, especially the Australian precedents, which you said, New Zealand precedents. Those are all the things which I think as in future, they are the ones which are going to come up day and day.
Yes.
Indeed, sir.
Canadian approach.
The Canadian approach. These are all Commonwealth, sir. So they will be useful for us because the Supreme Court constantly follows these dicta.
Yes, yes.
Thank you, sir, for that quote-unquote conclude magic terminology. Over to you, Somayajulu, sir. Your comments.
Sir, with the limited scope of judicial review, and now with the amendment to the specific relief act that injunction should not be granted in infrastructure projects, is virtually the entire contract law is being taken out of the scope of court's interference. Limited judicial review, no injunctions, even if you make out a good case. Is it a fact that this branch of law is being taken out of the court's purview, or you still think
all that is for this? All that is for the civil court, not for the constitutional court.
Sir, in my limited understanding, in administrative law, judicial restraint is what is commanded,
Exactly.
what is laid down for us. But I can assure you of one thing: at no point of time has the Supreme Court or the High Court, Supreme Court ever said or can ever say, or even under the Constitution, that judicial review under Article 226 and 277 can be totally excluded. If we find at a given point of time at the High Court level on the facts that yes, this calls for interference, you can be rest assured, sir, at least I have not hesitated to interfere. And I'm sure a lot of other colleagues have not hesitated to interfere either.
So we still have some freedom.
Chandrakumar is the
Yes, sir. Chandrakumar, first Sampath Kumar, then Chandrakumar. Yes. If the cat has been given the power to even test vires of a particular provision of service condition, the High Court is sitting in appeal over the cat.
Okay. Thank you. Thank you so much.
Thank
Thank
you.
you, sir. And we are indebted to you for introducing this wonderful speaker to this platform also.
No, no, my pleasure. My pleasure.
Thank you so much. Thank you all, sir.
Ramashan, sir, please.
Question, I think.
Really, it's a good lecture on the topic. See, this is always what is called a testing area as to how the Padman is principle of reasonableness can be applied while applying the question of judicial restraint and also judicial review. It is always depending upon the person who is sitting there and how to evaluate it.
Absolutely.
Because there may be cases where I think that even the categorically the Supreme Court says when you are not sitting in appeal of decision-making process, but if there is an arbitrariness in making the judicial process, where will you draw the line?
It is for us.
Because there is no guideline given as to how, which will amount to the arbitrariness in exercising the judicial making. It is always left to the court. That the danger is because nowadays because of the tailor-made contracts, you can choose anyone unless you are able to show the bias and also your specific interest of providing some benefit to some person excluding others. I don't think that the judicial review also will be limited if in that way. And possibilities of corruption and is little large. Anyway, it's a good presentation, sir. Very nice.
Thank you, sir. Thank you so
good
much.
Information on that.
Thank you, sir.
Open up for the open forum for discussions and deliberations. One doubt that has been lingering, sir. Government or the state, once it enters into contract or the field of contract or commercial transactions, do they have a different, what do you call, should they be treated in a different manner? Because today's government may change, tomorrow another government may come, and a contract already made. Is not the general principles of waiver, estoppel, acquiescence, etc. applied to them?
Yes.
Or common
Promissory estoppel has been applied.
Yes.
But only exception is there can't be any waiver or against waiver of fundamental rights, number one. And two, you must have heard of this principle. All my colleagues are there. There cannot be estoppel against the law.
No.
Against statute, definitely.
So, as you said, yes, in the realm of contracts, the state's action can be subject to scrutiny. There is absolutely no doubt about it. But as I was saying, if you are talking of the government tenders, pre-contract, yes, the trend of the Supreme Court is yes, interference under 226. Post-contract, any issue,
Yes.
the law is that the arbitration or the forum selection clause in the contract will apply.
Yes.
Now, one allied question, again on the same terms that you were posing the question, is what is the extent of interference or judicial interference in respect of a right that has accrued post-contract? Only two cases which I have already mentioned. One is AB International. That was an insurance contract. It went from Calcutta, and I was a lawyer that time. I remember I was briefed for a bank in this case. The AB International had entered into a barter contract with a Russian company for buying coal in lieu of selling tea. A lot of Indian parties, including Harrison Malayalam, ABL Limited, they were all participating in this process of selling tea to Russia in exchange for coal, and the government would pay these persons for coal. In connection with this contract, an insurance was made. Insurance was taken, an export credit guarantee insurance. There is a government body called ECGC, It's called Export Credit Guarantee Corporation, which gives insurance for this kind of export risks involved. When the coal did not come into India, or they were having difficulty in sending coal to India, they changed it to US dollar terms. That is the seller, buyer in Russian. There was a delay in payment, and finally the money did not come, was not received by ABL International, the Indian importer, the Indian exporter. The ECGC was insurance contract was invoked by ABL International. ECGC said we will not pay because this is a business risk loss. It is not a real loss that you have incurred. The Supreme Court said nothing doing. Even in the areas, this is purely an arbitrable dispute. This is purely a civil dispute under the insurance contract. Despite this, the Supreme Court said no. When everything else is decided, then there is no dispute at all. The Supreme Court says under the even in the area of contract, ECGC is a state and other authority under Article 12 of the Constitution of India. So you are bound to pay. And they forced ECGC to pay ABL International. This same ECGC decision was followed in another case called Joshi Technologies, which I had just referred to earlier. So even in the case of contract, the Supreme Court and Article 226 and 30, I mean, this is, it went from a writ appeal to the Supreme Court. Writ appeal. A writ was there in the High Court. So the Supreme Court says, yes, you have to pay. And we in Calcutta have followed that in the case of an admitted due by the Steel Authority of India Limited against one of its contractors. They said that you have completed the work, you have paid them, you have successfully completed, we are very satisfied, but we will not pay you because you owe another steel plant some other money. There is no clear cuts, details or particulars given. So we at Calcutta said that you are bound to pay. We followed Joshi Technologies and ABL International.
Would it be correct to say that a contract once entered into, a concluded contract with a government and a private party, change of government or government policies cannot intervene or interfere with the performance, and like any other ordinary contract, it will be evaluated and specifically performed?
Very good question. I will say it is, you are aware of the settled law of the Supreme Court, which says that policy decisions are never interfered with. But there is an exception. If, taking your example, your words, that is change of policy, that is under the earlier policy, a benefit was already conferred and guaranteed and or agreed to be given under a contract, that cannot be deviated from, that cannot be, you can't, wriggle away from that responsibility. So it will depend on the facts of each case.
From our state, a case had gone up, Golerans Weaving and Manufacturing Company, wherein the government had offered raw material, bamboo, at a specified rate. But it went back, when the government changed, it went back. It went up to the apex code. I think in that context, that doubt is raised.
There is one case from Kerala. I don't recollect the case. The Kerala government, with a view to promote tourism industry, said that we will exempt you from certain tax, luxury tax or entertainment, this tax applicable to the hotel industry for a particular year if you start or construct hotels out there. Then when the hotel was constructed, everything is over, time had elapsed. There was either change in the government, I don't remember, whatever, but the policy had changed. That is, the waiver was not going to be given anymore. So this exemption was claimed by that particular hotel owner, which was rejected by the state. Matter went to the High Court. I don't exactly recollect what happened in the High Court. The Supreme Court says you are bound to honor your commitment for tax exemption because you had given it at that point of time.
And normally government don't change. So only the ministries change. Government is there only perpetual succession and common seal.
They are bound by it. Governments will remain.
They are bound. Common succession, perpetual succession and common seal. Government.
Absolutely.
Practicality that arises the question.
Only the ministries change.
Absolutely, sir. We have a question coming up. Nawaz Jan, please, can you put your question?
Promissory estoppel principle.
Exactly.
Promissory estoppel are the principles of reasonable and legitimate expectation. Everything, sir.
Yes, yes.
All,
Nawaz, go ahead with your question. Please unmute yourself and put the question.
Before the question, there
Yes,
is
sir.
a small distinction there, Shyam.
Yeah.
Insofar as the English law is concerned, estoppel is used only as a defense.
oh,
Correct.
In
correct.
India, estoppel is used as an offense in the form of promissory estoppel.
yes, yes. Sword and
also a
shield.
defense. Both
Shield
sword
and
and
sword,
shield. Correct.
both.
That is the expression. That is correct expression. Sword and shield,
Thank you.
both. So that is how we have developed this concept of legitimate expectation, which has been really dealt with beautifully in the Kamadhenu cattle feed case by the Supreme Court. Yes, your question.
Nawaz, please.
Good evening, sir. It was an excellent
Good
session, highly insightful and engrossing. And let me come to my doubt. Especially the subject is of government contract, and it has always been a matter of great interest as well as great controversies. Whenever contract takes place between government and other parties, there used to be some sort of controversy, either politically motivated or anything like that. If 100 contracts take place between the private parties, nobody will come to know. If a single contract takes place between the government, people will come to know. Now, sir, my question is, see, when it is with regard to a particular thing that has happened around us recently, where the state itself is one of the bidders in a tender, and the state entrusts the documentation and other legal formalities to a law firm, a reputed law firm. And unfortunately or fortunately or as a coincidence, the person who is running this law firm itself happens to be a relative of one of the other bidders, who is also a party to this. So, I hope the
Yes. Carry on.
now, is there any legal bar? Is there any legal bar?
Nawaz, I think that it is a subjudice matter. Yes.
No, it's not subjudice. It has not gone to the court. No, so far it is not subjudice.
Likely to go, because today's paper,
Sir,
I think
I will put this very simple.
Until it has reached the court, it is not subjudice. It's a topic of general interest. So my question is there is any legal bar for a person prohibiting to take part in a tender where his relative is also a bidder to the party? First thing. Second thing, sir, we in Kerala have got our AG, a constitutional post, law secretary, and not many other legal advisors to the government. Still, whenever we are in need of legal expertise or opinion, we either fly to Calcutta or Mumbai or Delhi to get some legal firm. There is no dearth of qualified law professionals in Kerala. So these are the two aspects I would like to ask. First is whether there is any legal bar for a person to take part in the law firm or to be a part of the, transaction, where that party's relative is also another bidder. Second, is it permissible when there is AG in place, when there is law secretary in place, when there is a law department in place, is it necessary or permissible to hire outsiders for legal expertise? These are the two questions. Thank you, sir.
Sir, I'll put this very simply. Conflict of interest is a recognized ground for a bar in this country in any public process. Number one. Number two, I will give you an example in the form of an answer. The power sector in this country sometime in 2000 and 2001 was aggressively opened to private players all over the country and world. Power purchase agreements were entered into by the central government and various states in this country with a lot of private parties, as also who had collaboration with foreign parties on their own. Now, for engaging with these private parties, both the government of India and I distinctly remember the government of Maharashtra had engaged solicitors firms of repute based in London, because the other side had engaged a huge solicitors firm. I will not for a moment say at that point of time our legal personnel in India were incompetent. But if you see the contract yourself, and remember, I'm saying this because I saw the contract. Every small nook and nitty-gritty were taken care of by the respective parties to such an extent that if one party without notice to the other batted an eyelid, both sides will shoot each other with maybe 1,000 arrows within a split of a second. Now, it is persons who are experienced in this kind of negotiation of contract that are generally best engaged even to defend the government. But today the scenario in 2020 is quite different. We have huge law firms in this country who have their own tie-ups and other backups of experts. We have sufficient personnel. So it is for the government to really decide in the best interest of the government what kind of legal personnel it wants to choose. There is no strict bar as such. Ethical issues are not decided, and propriety issues are not decided by court really. As a judge, as far as I can say.
Yes, sir.
In autonomy, sir.
So there is no ban. There is no bar at all.
As such, there cannot be a bar. But then propriety issues, as I said, whether they should engage, should not engage is entirely for the state and its electorate to decide. It's not for courts to decide.
That is totally left to their reputation. To maintain the propriety is required for their reputation.
It has to be examined in the facts, sir. We can't speak so generally, but yes, if a particular expertise is not available in India, you can always outsource it to a foreign country.
Your advocate is the lead.
Thank you, sir. Thank you.
Good evening, Your Lordship.
Yes.
Thank you very much for your excellent informative presentation on today's subject. I have a couple of questions in my mind. One, suppose there is a clause among the general terms and conditions in the notice for pre-qualification bid that the authority reserves its right to accept or refuse any bid without assigning any reason. Is it legally sustainable on the touchstone of rule against arbitrariness and bias in an administrative action? Second is, even if it is admitted that it is legal and competent for that authority to do so, the authority not bound to have any reason, a valid and legal reason for such a gesture.
Now, this is
and third, the last question is whether a bidder who has been catering and servicing all the purchase orders to the same authority for the last so many years can be unilaterally disqualified without any notice and without affording opportunity for hearing to the said bidder.
Now, there are two parts to your three questions. The first question, whether a clause which says that the state reserves its right to reject any bid without assigning any reasons, that came into question both in one of the two in many decisions I had cited. Per se, that clause cannot be by itself faulted unless you are able to demonstrate before the authority concerned or the court that you had the administrative authority did not and could not have removed you or rejected your bid, or has rejected your bid without any valid reason, or contrary to, sometimes they may not have to give reasons, contrary to the tender conditions, that is subject to proof, number one. Number two, so in answer to your first question, yes, they can use such a clause is valid, but it can be tested on the touchstone of propriety, correctness, and whether you were validly rejected or not.
Yes.
Second thing, if a tender condition, as this questioner had arisen earlier, our learned colleagues had addressed this, tailor-made conditions to exclude a person who is sitting there as a supplier for the past 10 years.
Yes.
Tender conditions are made in such a way.
Yes.
I can assure you, going by the dicta of the judgments that I read out, clearly it is in the exclusive, especially the Michigan rubber case.
Yes.
Supreme Court has clearly said, yes, it is within the exclusive domain of the state to specify whatever conditions of the NIT. So, in Michigan rubber, the 4 bigger players who are manufacturers of tires were eligible to participate in the tender, whereas Michigan rubber, who was supplying rubber or tires to the Karnataka State Road Transport Corporation for 5 consecutive years, was excluded. Supreme Court said very valid.
My last limit of the question was regarding the disqualification of the bidder.
Now, disqualification of the bidder can be coming under various categories. Now, disqualification, he can be disqualified on financial grounds. He can be disqualified on technical grounds. It depends really on the terms and conditions of the notice inviting tender. If the bidder does not satisfy the conditions stipulated.
Everything is there because he had been serving and catering to all the purchase orders for the last so many years. The same authority.
Read Michigan rubber. It seems to be very close to your question. Your answers are all there.
Okay. Thank you.
Next, please.
I have Ashwini Fatke. Ashwini, can you just unmute and put your question?
Hello.
Yeah, go ahead.
Yes, please.
Yeah, sir. Good evening, sir. I have one question. Like, I work in a government company, so I handle tender related for the manpower. So I just need to know, like, is it mandatory that 3 tenders should be received, or without which we cannot open the tender? Or else, if we have received 2 bids who are qualifying all the eligibility criteria, can we consider those bids?
It entirely depends on the tender conditions. Your tender conditions should satisfy the basic requirement of Article 14, in the sense, not Article 14, reasonableness. Have you given a fair opportunity to all persons concerned who can give you the best service or goods? That will be the criteria that the courts will look at. If somebody, if you are saying you specified, you close the tender after receiving 3 bids. If there are so many other competitors, you are shutting out competition. So it will really depend on each fact and circumstance of each case. One cannot lay any straitjacket formula for these should be the ideal conditions and these won't be. It differs from procurement to procurement.
Sir, why I'm asking, because we did this tendering through this pandemic, so there was a lockdown process was also there, but we had the tender condition that the tender should be receiving in the hard copy along with the soft copy. So what has happened, we have received the copies in the email or in the tender visa portal, but we didn't receive the hard copy in hand. So can we consider those tender, or we have to reject the entire this bidding process and we have to restart those again?
See, this is my personal view. This is not because this appears to be more related to a particular case. It will be improper for me to make any observation as such. But my individual personal view, without going into any of the documentation, based exactly on what you are asking, is if you have received tenders by email, which is one of the mode of tendering, submitting tenders, that should constitute sufficient compliance. Prima facie. But then there may be other situations. Yes, brother Somayadilu, sir.
So if that is denoted as an essential condition, that you shall submit it only by hard copy, then maybe you cannot. If it's a non-essential condition, it can be relaxed.
That's a wonderful clarification by brother Somayadilu.
Essential, non-essential condition, madam. Like brother said, depends on your contract. If it is denoted as an essential condition, it cannot be relaxed under any circumstance.
Yeah, then I think,
the other case cited regarding DD from a particular bank, instead of one bank, another bank was given. It was not taken as an essential condition.
And the last question, I'm just asking many questions because I handle this work. So just this CVC guidelines to be followed or GFR 2017 to be followed?
I think you asked the industry personnel this.
Acha, fine, sir.
I think an experienced bureaucrat would be able to answer that better.
Okay, sir. Thank you so much, sir.
Thank you.
Next, Advocate Vipin Das, please.
Yes, sir. Good evening, sir. It was an excellent
Yes, sir.
session. Yeah. My question is, sir, there is a practice that there is post-bidding negotiations in some places.
As I was telling you, post-bidding negotiations have been happening in this country and have not been interfered with if equal opportunity is given. The first post-bid negotiation that happens is with regard to the technical bid. After certain clarifications are sought, ex-bidder who has already submitted his technical bid and financial bid says, I can, pursuant to your clarification, yes, I can do this, I can also do that. So then an opportunity must be given to all the tenderers to change those conditions or meet those conditions. It's an equal opportunity regime. Consequently, an opportunity has to be given to all bidders, including the person who has who has given the clarification or who has participated in negotiation to change his financial bid. And the others also are entitled to change their technical and financial bids. It is permissible. But post-financial bid, if it is narrowed down to 3 or 4 persons and it is stipulated in the tender conditions that negotiations are permissible, it will all depend on the NIT conditions as communicated to all parties.
Okay, sir. Thank you, sir. Thank you, sir.
Yes, please. Next.
Ajay, all to you.
No, I have nothing to add. I was just a good listener today.
Thank you. Dr. Vijay Kumar, any comments, sir?
No, wonderful presentation touching each and every pros and cons. It's wonderful. That's
Thank you, sir.
the area of this subject. Thank you very much.
Thank you, sir.
Thank you very much. So over to you, Prem.
So that was indeed a wonderful presentation. And I just have one doubt. Whether amendment of the clauses of a tender, which is floated by the government, can be done after selection of the final bidder.
That will be, it will really depend on the situation. Because if the contract, for example, the contract is entered into on the terms as stipulated in the tender, original tender, in which everybody participated, the person successful is done. Subsequent to the contract or before the contract is entered into, in many cases it is seen that subsequent to contract, the scope is changed, enlarged, altered. It is entirely upon the parties. But if some new unfair advantage is given to this successful bidder, which any other successful bidder could have, any other bidder could have easily performed, it will depend on the facts and circumstances of each case. Gentlemen, one cannot generalize like this. But I will say it is not impossible. It is quite possible.
No, but that's the technology which is now used by many of the states or many of the parties. Initially, because I happened to work as a contractor for about 10 years before I entered into this field. There is a certain of the items which will never be executed will be put in the tender, and the man who is experienced, he quotes absolutely a zero price for those items. Eventually, what happens is after he enters, he becomes the lowest, he gets the contract, that item is removed because that was never intended to be executed.
My goodness, that is tailor-made. Tailor-made.
Huh?
Is it tailor-made?
That's a score that no. These are tricks of the trade.
Very well-established technique.
I'll give you another example. Just Chaudhary, I'll give you another example. In the Northeast, there was one very famous player in major infrastructure contract. Every tender he submitted, technical side, everything is filled up. Financial side, every page is blank. Every page. And he gets to know from his sources what is the lowest bid, and he will bid exactly slightly lower than that. It is entered.
inside information.
This is from my litigation days, lawyer days.
All these are trade secrets.
Yes, sir.
Anyway.
If it is discussed and divulged and if it is reopened, probably most of will be allowed to face inquiries. Most of them will be placing for inquiries. For passing of
And so whether there is any benchmark regarding the touchstone of reasonableness of the policy decision.
Sorry.
Whether there is any benchmark regarding the touchstone, I mean, of the reasonableness of any policy decision, or whether
no, sir. The Supreme Court has only laid down to the extent that policy decisions per se can never be interfered with, except if the policy is touching on any existing and vested rights. These are the exceptions. But then this will also depend on facts and circumstance of the case.
No, sir. But I think in that Reliance Telecom case, there's a 2017 4SCC decision. I think something has been observed by the Supreme Court.
I tell you, there can't be a straitjacket formula.
There cannot.
There just cannot be one. It has to be on a case-to-case basis.
Correct, sir.
Thank you, sir. Sir, that is bringing us to the end of the 110th session. What a wonderful experience, sir. I mean, the deliberations, the way, the express manner in which the only complaint that can come is the speed, nothing else. Otherwise,
high speed variety.
High speed. Wonderful, sir. Wonderful. And the way in which this complicated and intricate, relevant subject was simplified and offered was the platform. Everybody in the platform is enriched, sir. I mean, it was really great. We are thankful to Justices Ramkumar, sir, Ramakrishnan, sir, Somayajulu, sir, Justice Kodandaram, sir, all of you, and Dr. Vijay Kumar and Vijay, almost all of you wonderful participants for being part of this journey. The journey continues. We have the 111th session on 27th, Thursday. That is by Dr. P. Puneet. He is an Associate Professor of Law, Center for Study of Law and Governance, JNU, Delhi. He'll be addressing us on the topic, Regulation of Online Falsehood in the Age of Social Media, Reflections on Constitutional Limits.
Very excellent, wonderful topic.
Yes, sir.
I will be in court on that day.
Absolutely. We'll all be here on 22nd.
Recorded thing.
And we take this opportunity, or rather we would like to take advantage of this opportunity to again request Justice Kodandaram, sir, to address us in this platform.
I second that.
You should take the initiative, brother. Position there, you'll have to take the initiative and selection of topic can be yes.
Yes.
We want future visits. Future visits are welcome.
No, you should, sir, you should give him a topic that can,
yes. That
he believe in ordinary gentle speech. He will
that
take
we will give.
to it.
That we will.
He's not afraid of expressing himself. A very rare quality in a judge. He will take very
This platform requires that, sir.
You know, what I can say is what Soumyajulu says, because I am about to 1 year to retire. So where is the, why should I be afraid of anybody?
Still remember, sir, there was a program in Vijayawada where the DRT of judges and officers were called and the bank sponsored everything. So everybody was praising the bankers for, their services to the nation. And Justice Kodandaram gave them an earful of how they were ruining the nation. In the presence of a sitting Supreme Court judge.
That is what this platform requires.
You should, sir.
No, I know. I really go along with Justice Kodandaram on that aspect because the persons who are following and who are properly paying are not benefited. The defaulters are being benefited. Is it not, Mr. Kodandaram?
See, the adhesive contracts, in many of my brothers and many of the advocates also would have borrowed some money for house purpose or whatever purpose. Did any of you had an occasion to read? Did any of you get a copy of the agreement which you have signed?
No, even they won't, normally they won't fill up, but fortunately in my case, they took long time and filled up and then asked me to sign.
Agreement in terrorum.
Yeah, absolutely. In fact, it's a printed format.
Yes.
From agreements, contract of adhesion, take it or leave it. No bargaining power, no way you can negotiate, and you call it a contract.
Shyam, there's a very interesting comment.
Joking.
The contract is so one-sided, I'm surprised it is printed on two sides of the paper. So one-sided and surprised.
Wonderful. My God.
Right.
Thank you very much, all of you, for sharing the information, knowledge, wisdom, and revitalizing this platform once again. And the season 2 is yet to see more and more such speakers and such deliberations. So till we meet again coming Thursday, 27th August at 3:30, please do take care and stay safe.